Doe, the Chair of the Committee on Public Works and Operations. Today is Thursday, February 6th, 2025, and I'm calling to order this meeting of the committee in room 412 of the Wilson Building, as well as over the Zoom platform. The time is 9:41 a.m. Before we dive into the performance hearing, I'd like to take a moment of silence for Judge Paul Handy. Judge Handy passed away last week, and he was an administrative law judge with OAH for 21 years. At this time, let's take a moment to honor his public service and his legacy. Thank you. Today's performance oversight hearing is for the Office of Administrative Hearings, also known as OAH. OAH is an independent agency that serves as an administrative court. It's tasked with providing a fair, efficient, and effective system to manage and resolve administrative litigation for district residents arising under DC law. OAH is a neutral, impartial tribunal that holds hearings and decides appeals from government decisions. Its jurisdiction has expanded significantly since its creation in 2001, and it now conducts hearings and resolves cases involving a wide variety of district agency, board, or commission actions. OAH is supported by the Advisory Committee to the Office of Administrative Hearings and the Commission on the Selection and Tenure of Administrative Law Judges, or COST. The Advisory Committee has 8 members and is tasked with identifying issues related to administrative adjudication and making recommendations for improvements. COST is established by law to appoint, reappoint, discipline, and remove OAH administrative law judges. Some of the agency's key accomplishments that I'm happy to report include an overhaul of its rules, which went into effect in December 2024, the launch of the online final order database, which makes cases searchable online, and finally, their perfect score of 12 out of 12 for their compliance of the Language Access Program. This accomplishment in particular is extremely important for the agency because of the high number of unrepresented litigants that interact with OAH. However, we will also explore the other challenges the agency still faces, like the substantial caseload, staffing shortage, and the accessibility of final order database. We'll be hearing specifically from the Chief Administrative Law Judge, M. Colleen Curry. I thank OAH for its responsiveness to this committee's request for information. I look forward to hearing more about the agency's successes and improvements over the past year, as well as the challenges the agency currently faces, so we can help them work through and build on their foundation to meet their mission. And I look forward to hearing from both our government and public witnesses today. The committee values your input. It's just some logistical instructions for today's hearing. We do have witnesses both in person and on the Zoom. When I call your name in person, please come forward to the witness table. And on the Zoom, we will be promoting you when it is your turn. So make sure you accept that invitation. And once you're promoted to the panel, then you'll be able to turn on your camera and your microphone. If you have any trouble in the Zoom, just send a message to one of our committee staff. You can also email publicworks@dccouncil.gov if you need help resolving any issues. Our first panel here in person includes Becca Steele, Legal Aid DC Staff Attorney, Christina Jackson, Washington Council of Lawyers Executive Director, Fritz Mulhauser, DC Open Government Coalition, Nancy Drain, DC Access to Justice Commission Executive Director. Good morning. Thank you for being here with us today. You may go in the order that I called you. When you're ready, just don't forget to hit the button to turn your microphone on.
Good morning, and thank you for the opportunity to testify. My name is Rebecca Steele, and I'm testifying in my capacity as an attorney with Legal Aid DC. Legal Aid practices at OAH to help district residents obtain crucial safety net benefits, including cash assistance, food assistance, medical insurance, and unemployment benefits. Increasing OAH case numbers have left district residents waiting unacceptable and, in some cases, unlawful amounts of time to have their cases at OAH heard. In the first half of my testimony, I'll speak to the scope of OAH delays and the impact they've had on district residents. Then I'll outline the steps that Legal Aid recommends the Council take to address this issue. As I'm sure you'll be hearing more about today, in fiscal year 24, OAH hit an all-time record for new case filings. Filings are quickly outpacing capacity. OAH was only able to dispose of 75% of the cases filed in fiscal year 24. Public benefits cases comprise a significant component of this increase. The increase in volume has caused unacceptable backlogs, which in turn cause immense hardship for district residents. In the majority of public benefits cases Legal Aid filed on behalf of clients in November and December of last year, we're still waiting on an initial scheduling order. There's been no movement whatsoever. One of our clients is appealing his SNAP benefit amount. He has special dietary needs because of his medical diagnoses, and he's unable to meet those needs without his full SNAP entitlement. Legal Aid advised another client last year who filed an appeal of the wrongful termination of her interim disability assistance benefits. This client had no income but had to wait for 3.5 months for her initial status conference. In the interim, she was unable to keep up on the costs of maintaining the storage unit where she stored nearly all of her possessions. By the time the case was called for the initial status, the client had already been unable to catch up on the accrued late fees and lost decades worth of memories in that storage unit. The benefits district residents are seeking when they go to OAH simply cannot wait. These delays also put DAC out of compliance with federal program requirements, such as the SNAP rule mandating that a decision must be reached within 60 days of a request for a fair hearing. For fiscal year 24, the average time from when a SNAP appeal was filed to the initial event in the case was 83 days, already surpassing the 60-day limit. In order to address this backlog, we urge the Council to consider staffing, oversight of other agencies, and monitoring steps that OAH itself can take internally. First, staffing. OAH caseloads have increased, and more cases require more staff, including support and administrative staff. OAH currently has multiple vacancies where hiring is on hold due to budget constraints. We urge the Council to ensure that OAH is able to fill these vacancies and hire additional staff to process cases in a timely manner. Second, we urge the Council to increase oversight of other agencies whose repeated errors are the source of numerous fair hearing requests pending at OAH. In Legal Aid's experience, the majority of public benefits cases filed at OAH involve no real legal dispute. DHS agrees that the agency has made a mistake. However, DHS pathways that are designed to resolve these types of issues, like the service centers, the call centers, and escalation procedures, are entirely ineffective. So filing at OAH is the only way to get DHS to correct its errors. But instead of serving its intended purpose of adjudicating contested cases, this means that OAH is monitoring DHS as it reaches and implements its own decisions. OAH is bearing the burden of the dysfunction at DHS. By increasing pressure on DHS and other agencies with frequent errors, like WMATA, the Council can decrease case numbers and alleviate the burden on OAH. Third, we urge the Council to monitor and encourage policy changes at OAH itself. OAH must leverage its available resources to address these high case numbers. OAH has a new policy of only scheduling an initial status conference after an administrative review conference, or ARC, has already taken place. However, the law is clear that the use of an ARC is optional and that it shall in no way delay the fair hearing process. Given how slow DHS's current ARC scheduling is, OAH's practice of waiting to schedule an initial status conference until after the ARC prevents district residents from having their cases heard in a timely manner. This must be changed. Additionally, OAH must do a better job of triaging cases, for example, with the emergency hearing option in the public benefits cases. This past fall, Legal Aid filed an emergency fair hearing request on behalf of a family experiencing homelessness who faced wrongful terminations of their wrongful terminations of their medical insurance and cash assistance, as well as wrongful reductions in food assistance. But the Office of Administrative Hearings denied the request for an emergency hearing. This was precisely the type of case the emergency hearing procedures were designed for and should have been recognized as such. OAH has made important progress relating to accessibility, including publicly releasing substantive orders and expanding the OAH Resource Center. We believe that OAH can also make major strides in reducing backlogs. We appreciate the Council's attention to these issues as well as OAH's ongoing efforts, and we look forward to working with everyone to achieve these goals. Thank you.
Thank you very much for your testimony. Jackson.
Thank you, Chairperson Nadeau and members of the committee for the opportunity to testify about the performance of the DC Office of Administrative Hearings. You know, OAH is an essential resource for DC residents who receive vital support from DC government agencies. Today, I'm going to talk about three key areas: the significant increase in OAH caseload and its consequences, the final order database, and the resource center. As you're aware, OAH is where district residents must first go to address and resolve disputes about whether they've received appropriate government support and benefits in critical areas of daily life. The volume of cases presented at OAH each year is staggering. As my colleague said, it was a record high this year with 33,744 new cases filed in the past fiscal year. This represents a 28% increase in total case filings compared to FY23 and a 57% increase from FY22. Of these new cases, approximately 75% have been decided, but that still leaves a backlog of over 7,000 undecided cases. As the OAH annual report noted itself, the inability to obtain 100% case disposition may cause delays in processing and adjudicating cases, which could negatively impact access to critical public benefits for individuals. As you will hear from all of the legal services providers, it is not may, it is. This is particularly troubling given that OAH has experienced a steady increase in appeals that relate to the benefits that my colleague talked about earlier. The increased case filing figures underscores the findings of the 2023 OAH staffing study, which concluded that the agency was understaffed for its then current caseload. And in her testimony a year ago before this committee, Chief Administrative Law Judge M. Colleen Curry warned of the potential for a dramatic increase in caseload with the concurrent need for increased staffing. Our written testimony provides details from the study on required staffing to properly manage the caseload, so I won't go into that here. But unfortunately, these staffing increases don't appear to have been possible with available funding. Further, OAH's inability to fill vacant positions exacerbates this problem. As of December 2024, in the clerk's office alone, there were 8 vacancies. We asked the committee to inquire how OAH intends to fill vacancies quickly or discover any impediments to doing so. Further, we urge this committee and the council to critically examine the FY26 budget, proposed budget for OAH, to address the concerns raised by the Chief Judge and the staffing study to ensure greater access to justice for litigants appearing before this critical tribunal. The most significant consequences of the increased caseloads and the insufficient staffing is delayed justice for DC residents. And as my colleague stated, we recognize there are certain factors leading to the increased caseloads and case disposition time. For example, the budgetary constraints on hiring and the overall care and accuracy with which district agencies issue the underlying decisions that are appealed, that are ultimately dependent on circumstances outside of OAH's control. Nonetheless, the need for prompt adjudication of OAH cases is uncontroverted. Many OAH appeals involve basic necessities such as medical care, housing, and food supplies. Delays in resolving these cases place additional burdens on clients and their families. Advocates have noted increased delays in scheduling hearings and some troubling examples of denials of emergency hearings. Ms. Steele talked about the public benefits cases. There are others. We urge the council to use its oversight authority to explore and resolve this issue. And we also urge OAH to consider procedural changes that are within its control to expedite the case processing. I want to highlight the final order database. We are thrilled that it has been launched. There are 2 drawbacks. One, a simple keyword search isn't available, and so that makes it very difficult for the general public and practitioners to look for decisions. And only the cases post October 1st, 2024 are now available. So we have a little bit of a ways to go. We asked the committee to inquire as to why OAH is lagging behind other government agencies in the use of this technology to improve access to essential case information. On the flip side, we applaud the chief judge and her colleagues for the attention they have given to making concrete and important improvements to the OAH Resource Center. The Resource Center is critical to those litigants, as we've testified before, upwards of 90% who have no lawyer and navigate this complex legal procedure by themselves. This is where the OAH Resource Center plays a critical role. Their increased staffing in the Resource Center manager and Resource Center coordinator are welcome, and we feel there are additional improvements that we are thrilled anxious to help support. Thank you so much for this opportunity to talk about OAH. I'm open for questions.
Thank you very much, Mr. Mulhauser.
Good morning, council member and other members. I'm Fritz Mulhauser. I'm the co-chair of the legal committee of the DC Open Government Coalition. We've appeared here for many years advocating for better access in many agencies to government records, to government data, and government meetings. And particularly in OAH, we've been concerned about access to published opinions, which unfortunately, for the 20 years of the agency history have not been published. But as you've already heard, it's good news this year. The agency has been able to begin putting online some of its opinions. With thousands of cases, often repeating similar fact situations, the ability of the public to understand how the agency views a food stamp benefit decision or a trash ticket or a school suspension is crucial. And unfortunately, the agency has been essentially putting out a body of secret law for decades. It's a violation of DC law, which requires all agencies that decide cases to publish their opinions, and the remedy has been long awaited. It's great that they've started. Unfortunately, as you've already heard, it's a work in progress. There are only 300 opinions posted. If you take their case closure record and divide by 12, they closed last year 2,000 a month. Where are all those? Maybe they don't issue opinions in many, but the pace appears to be slow, and the question of backlog of getting opinions published is unanswered. The ability of the public to use this resource depends on being able to take their case and look in the record to see how it's been handled before. And you just can't do that. The system offered by the office allows you to search on administrative details such as the judge's name or the OAH case number. That's not a search functionality that helps the public. If you look at the Office of Employee Appeals, which decides cases, you can look at their roster of opinions. And as I did the other day, I looked up insubordination. Insubordinate employees are my kind of people. And I could find dozens of cases deciding if the employees truly deserve discipline or not. You can't do that at OAH. If you look up even the agency where you think your case might arose, you find descriptors of cases attached in the table that's produced. But for example, all DPW tickets that are posted, opinions that are posted, say trash. Is that enough? Even worse, in other places, it says infraction. So the tools that the office provides the public are just not sufficient to really be useful. And this is not a heavy lift. The Office of Employee Appeals example shows that other agencies are managing to do it. Your questions to the office this year were sensational in probing about the online opinions, and we encourage you to pursue all your questions as aggressively. The problem of past opinions is significant, but there is software now that looks at documents and will under training of artificial intelligence and sound computer science, it will reliably redact personal information, which allows you to efficiently process lots of pages and take out the bits that should be private. They should look into that. I associate ourselves with the remarks of all the colleagues. These are existential moments for this agency. Their workload rises, their resources do not, and they need this committee's help. You cannot rebuild the plane engine that needs a repair while you're flying it. You must provide some prudent staffing increases so that they can do the job of analyzing the work, seeking all possible efficiencies, while also managing an incredible caseload, which, as the colleagues have said, is of daily vital importance to the residents of the city.
Thank you.
Thanks so much.
Thank you, Mr. Mulhausen. Ms. Drain.
Good morning, Chair Nadeau and committee staff. My name is Nancy Drain, and I serve as Executive Director of the DC Access to Justice Commission. I'm glad to be here today to talk about the critical role that OAH plays in our civil justice system. And I know that you understand how important OAH is to the well-being of district residents. To ensure prompt adjudication, a well-functioning and appropriately resourced OAH is imperative. In our testimony today, the Commission would like to highlight 4 areas: the positive improvements in providing assistance to self-represented litigants, the need to ensure OAH has sufficient operational resources, how council oversight could help us better understand and address the factors leading to OAH's growing case filings, and the importance of developing strategies to ensure OAH efficiently supports the district residents who rely on it for help. We'd like to begin by applauding OAH for ensuring that there is dedicated staff to support the Resource Center. The Resource Center makes staff available in person or by phone to provide information to litigants with questions about OAH's procedures, which is especially critical when the vast majority, upwards of 80 to 90%, of litigants navigate OAH without legal representation. We thank Chief ALJ Curry for her commitment to support this critical strategy. Staffing deficits continue to be an area of concern at OAH, with at least 2 factors at play. 1, inadequate budget allocations to expand staff, and 2, a high number of unfilled vacancies. OAH's budget must increase if it is expected to meet its mandate to adjudicate the growing number of case filings. This is not a new concern. It was highlighted in the 2023 McNamee report directed by this committee. OAH also needs to be able to fill its vacancies to do its work. OAH's performance oversight responses list current vacancies, including 8 legal assistants that are, quote, on hold in Q1 due to FY25 budget constraints. The council should inquire as to why these positions cannot be filled within its approved FY25 budget. The significant increase in OAH filings is cause for alarm, especially if OAH's capacity continues to be stagnant. Because OAH's core function is directly related to practices across multiple district agencies, the council is in a unique position to play a role in examining and diagnosing why so many district residents and district agencies themselves must resort to using OAH to secure satisfactory results. District agencies should bear some responsibility for identifying and addressing persistent issues at the agency level, as opposed to relying on OAH to address them. Heightened data collection and case tracking at OAH, council oversight, and collaborative efforts with stakeholders could each play a role in problem solving here. Similarly, OAH may need additional tools or levers to increase compliance with its procedures in order to meet its goals for efficient case adjudication. OAH's performance oversight responses cite, quote, limited availability of staff from sister agencies to attend hearings, quote, the legal deficiency of agency filings, and agency-related delays such as those described by Ms. Steele that hamper its ability to timely process cases. The council should explore with OAH what tools it has or needs to do its work effectively and to ensure compliance with the timelines that ultimately it is bound by. Finally, OAH needs support to pursue improvements that will increase its efficiency and productivity, especially in the area of technology, another recommendation of the McNamee report. OAH's performance oversight responses reveal needed improvements for, quote, extremely outdated systems that are, quote, mission critical, yet currently limited by budgetary constraints. We at the Commission have enjoyed a positive working relationship with OAH. An ALJ sits on the Commission, and we convene regular monthly meetings with OAH representatives and other stakeholders to foster dialogue, problem solving, and collaboration. We stand ready to partner with OAH on these issues and to draw greater attention to the need to sufficiently resource and modernize OAH. We thank this committee for its attention to OAH and looked forward to our partnership with this committee to ensure OAH has what it needs to serve district residents. Thank you for the opportunity to testify today.
Thank you very much, all of you. Ms. Steele, thank you so much for all the work that you're doing. What has the agency's response been regarding the delays your clients are facing?
I mean, you know, we try to flag and distinguish the cases that are the most urgent through the emergency filing. And as I've said, we haven't had success in that in all cases. Often, though, the cases are now getting resolved, you know, by DHS, it's just taking too long. And even if the agency is able to hold status conferences earlier, that helps put pressure to get them resolved. We see in hearings that do require further follow-up that even after the initial status conference, there are delays that ensure that even the second hearing, the third, are also farther out, delaying the disposition as the case as the whole. And I'm sure Chief ALJ Curry is better equipped to, you know, explain exactly what's going on behind the scenes, but it seems, you know, that the response to us is that the hands are tied and that, you know, there's too much volume in terms of whether you're asking about OAH's response. To the extent you're asking about, you know, other agencies, we can address that too, but I know we're here today to talk about OAH specifically.
Sure, but I'm interested in something you just said about DHS. So you're saying that when you're making the emergency filings, sometimes DHS comes back to you in the meantime to resolve the issue on their own?
In some cases, yes.
Do you think the emergency filing is what triggers that?
I don't think DHS is distinguishing between emergency or not. There's a couple staff at DHS in particular who are eager to help resolve cases that we flag as urgent. The problem, of course, with relying on that is that that's only possible because of our unique channels as legal aid and as attorneys. And as we've discussed, the majority of people while we are often able to resolve cases before a hearing, if you don't have those connections and you don't have a lawyer, there's no channel whatsoever for you to do that.
Yeah. One of the things that I've spent a lot of time thinking about is just what you were mentioning in terms of getting upstream. A couple of you mentioned this is, you know, why are there so many cases coming from DPW or public benefits cases? So one of the proposals out there is an ombudsperson for DHS. Is that something that you all are involved with or thinking about?
It is, and I think it's something that could be helpful if the ombudsman is able to have the authority to resolve issues. I know that's something that has been helpful in the Medicaid context. We are often turning to them prior to filing a fair hearing, and in some cases, we are able to avoid a fair hearing.
And I think the education ombudsperson has also been able to help in that way. And those are both examples of internal ombuds people as opposed to the independent ombudsperson for children that we created. And I think that there are benefits to both models, but I do think that when it comes to case resolution, an internal ombudsperson might be a better way to go because that person then is like inside the agency and then you have OAH for further recourse. Just, you know, spitballing a little bit here, but
no,
okay.
Our preference would certainly be to resolve everything we can within DHS, and then to the extent we can't, for folks to have a quick channel to have that greater level
Yeah.
of accountability at OAH.
Makes sense. And Ms. Jackson, in your testimony, you said you're hopeful that the Resource Center will institute new programs, engaging law students and volunteer attorneys who can assist clients. What do you envision those programs to look like?
So if you take a look at, for example, the self-help centers in DC Superior Court, I think that's a model that's incredibly effective. DC Superior Court, the chief judge brought on additional dedicated staff to coordinate all of those pro bono efforts. The Resource Center is doing a good job of being able to manage their own staff, and we're thrilled to see those positions come back and have them be permanent and have them be funded. And we looked to the DC Superior Court model, the self-help centers, as a way to expand what they can do. And we certainly have volunteers who are eager to help, and so we can assist in putting that plan together.
And you and Mr. Mulhauser both mentioned the searchability functions of the final order database lacking. And I certainly understand that. He mentioned one specific agency that has a better version of this. Did you have one in mind also? Any other agencies that are doing this right?
I don't, and I apologize,
No,
but
no.
I can certainly take a
Totally
look at it.
fine. Not trying to put you on the spot, just trying to have a conversation. All good. And Mr. Mulhauser, you said in your testimony that OAH needs to optimize recruitment and retention to get legal and IT staff in demand categories in today's job market. What advice do you have for the agency on how to optimize recruitment?
Far be it from outsiders to know the workings of DC personnel systems, and the federal government is under the same pressure to hire quicker, better. So it's a widespread problem. But what I've heard from OAH colleagues is that they feel unable to offer competitive salaries. And that reflects the classification of positions or grade level. Salary is tied to the complexity and span of the work. If there are ways for OAH to better classify its staff to support competitive salaries, they should find those out pronto from effective government managers everywhere. What exactly is the level of staff skill and experience that will support the salary that recruiting officers know they have to meet to snag the best candidates? Government is classically a poor competitor in the technology space, but every agency faces this. So we hope OAH gets advice about how, if you will, to game the system, but more accurately, to justify the necessary salaries to be competitive. And then they need to create a workplace which will retain people. One of the technology positions was filled after a long wait, and the person only lasted a few months. I have no insight into why, but the consultant reports pulled threads together to say that the difficulties in the office make for a stressful workplace, which makes it hard to keep people who have many options. So recruitment and retention and overall an agency design of work that keeps the best people, those will all help solve the staffing problem.
Thank you. Regarding the searchability aspect of your testimony, do you think that we've got the right technology, it just needs some tweaks, or are we on the wrong platform?
OAH was not transparent as it designed the system, despite this committee's request that it work with Octo and civil society. So we're not sure all the considerations that went into designing what they have put out. We obtained the procurement papers by Freedom of Information request, and they didn't spend much money on it. Complicated systems may take money, so they may have been hobbled in that regard. But searchability of text is a widespread need of many legal agencies, law offices, and so on. It is being addressed by all kinds of rapidly evolving technology, And the solution that OAH has from its vendor, a company in California that has provided its case management system for years, the solution that they have purchased is simply the most basic off-the-shelf product that could have been imagined. We wish for them some further exploration of all the technological ways they could meet the need of the public better than they're doing today. And the Office of Employee Appeals is a striking example. It can be done with DC government records on a DC government website.
One of the things of interest to me, and we do see some of this in the annual report, is just which agencies are referring the most, where the case is coming from, but also which are substantiated and which are not, right? Because that tells me more than how many cases you have. But for example, if illegal dumping is, not substantiated 60% of the time, then that's a conversation we need to be having with DPW, right? Which I get to in this committee, actually. But I think it's equally true of the human services, the public benefits cases, and more so because these are people's livelihood. So I think the more public information we have on that, the better. But it's also something I talk with my colleagues about in oversight is, hey, check out the records here in the annual report on your agencies and your committee, because you want to know if these are areas of follow-up for your oversight as well. So I think it's all the more information out to the public, the better, not just to the council. Ms. Drain, you said in your testimony that OAH lacks sufficient resources. Specifically, it lacks inadequate budget allocations to allow necessary expansion of existing staff and a high number of unfilled vacancies. How does the Access to Justice Commission fill in the blanks for the things the agency isn't able to provide? Where do you fill in the gaps?
Is your question, how can the sort of civil justice system fill in these gaps if they continue to not have efficient?
How are you right now? I mean, how are you having to do so?
Yeah, well, I mean, I think that you've heard that the consequence of these lack of resources is delay, and that I don't know that there's a way to fill in that gap. OAH, at the end of the day, we're reliant on OAH to process and adjudicate these cases. There's no equivalent of that short of a settlement outside of court, which you've heard people with lawyers, which is the vast minority, are sometimes able to do. But OAH is an essential function. And if it's not adequately resourced, we'll continue to see these gaps in access to justice. And I feel like I'm not answering your question, but I think there is no answer. OAH needs its resources to do its work. Although, again, as you were just pointing out, I do think examining activities at the agency level could relieve the burden on OAH to become closer to what their budget allocations will allow them to do. I mean, I think that there's lots of different approaches or strategies to try to diagnose and address this problem, but I feel like the budget inadequacies come up every year, and there is no solution to that. They need more people. And I mean, just looking at the significant increase in cases, I mean, it's just common sense, right? If their case numbers are increasing in the way that they are, you can't just keep the workforce stagnant. But again, I do want to just mention the vacancy issue too, because those are, I mean, from my understanding, those are budgeted positions that are just sitting empty. And that I think is a real concern, because that's even, that means that they don't even have the budget that they've been allocated, which itself is inadequate. So I think better understanding what's going on with the vacancy situation is something you can do immediately. So I hope that answered your question.
Mr. Mulhauser.
Let me draw your attention to an important, very broad approach to these problems. The classic notion of an administrative law judge is someone who looks at a case, looks at the facts, looks at the law and regulation, and decides, was the benefit denied properly or not? Was the suspension well justified? The remedy in such a situation is for the judge to write an opinion saying case dismissed or agency should do a do-over and fix it. expanding the ability of a judge who sees many instances of problems to direct a broader remedy is an interesting problem. In the long term, that would send a signal to executive agencies of systemic problems that need to be fixed. The administrative judges have for years believed they had no power to go beyond the four corners of the case in front of them. They wished for greater authority, but they weren't sure. The DC Court of Appeals 2 years ago decided that judges do, in the proper circumstance, have the authority to order broader relief, order the mayor to obey the law, if that's the problem. And this is a profound and significant augmentation, enhancement of the ability of judges to deal with systematic problems. If the department computer can't promptly process applications, that's going to be the basis for numerous complaints. Why can't they just fix the computer problem with an order from the judge? The Court of Appeals says, under proper circumstances, judges do have that broader authority. The executive doesn't agree with that, and there's a bunch of appeals still fighting it. But it's a very interesting question of, if thousands of cases present common situations of agency mistake, let's fix the mistake. And the judges can do more according to the courts.
And if I may, I think this is where the council and this committee in particular is a key resource. The upstream, as we discussed earlier, there are, OAH works under memorandums of understanding, right? So where is the authority for OAH to be able to set up a process for how the cases are filed? If you go back and look, agency by agency have all sorts of different ways in which the appeals are filed to OAH. So there are lots of small places in the system that make a big impact. The problem is OAH is so busy drinking from a fire hose with respect to the cases they're adjudicating that that additional strategic planning is probably beyond their scope. And because it is a multiple agencies and multiple different MOUs, it's very difficult to go back and through and make a uniform process. And so we're hoping that this committee, now that we're looking at that upstream issue, can also use its oversight authority with those agencies. Perhaps it's a legislative fix with respect to how the agencies file the appeals with OAH, but we'd like very much to work with the council in order to help OAH do the job that they have to do, because there are pieces that are out of their control.
Take a look at a 2017 piece of legislation that attempted to fix some of the problems of the authority of OAH, and it was passed, but some parts required funding, and so the entire statute has, to my understanding, never taken effect. But these issues are longstanding, were the subject of the auditor's analysis in 2016 and addressed by the council in legislation. And revisiting that would be in light of new realities and in collaboration with the agency and so on. But it could be a valuable step.
Thank you. I'm going to wind us down, but could, Mr. Mahauser, could you send us the court decision that you were referencing when you have a minute? Okay, great. Very good.
It's also referenced in my testimony in the notes.
Very good.
It's
Okay.
referred to as C-O-E.
COE. Okay. The court decision is in his testimony. Thank you all very much. Our next panel is joining us virtually. Christine Phillips, David Malaf, Kathy Henderson, Maddie Leroy Thorpe from the COPE Red Hats Patrol, Nyasa Mitchell, bred for the city senior legal fellow. If you can just give us a moment to get everybody on the panel. Oh, nobody's in the Zoom. That seems strange. Well then, I guess that's our only panel. That has never happened before. Okay, well, let me just say, if you are currently in the Zoom and I called your name, double check that your display name is the same name you signed up with, because we do not see anybody in the attendees right now with the names that I called. And thus, nobody will be promoted to the panel. Or you can raise your hand in the Zoom to be promoted to the panel. Okay. Last call. Anybody in the Zoom who wants to testify today, please raise your hand. Anybody here in the room today that didn't have a chance to testify that wants to testify? Okay. Yeah, it's never happened before, but that's okay. We have lots to do today, a long conversation that we're going to have with our chief judge. So, that concludes the public testimony for this hearing. We'll now be joined by Colleen Curry, Chief Administrative Law Judge for the Office of Administrative Hearings. So what I'm going to do before you begin is have anybody who will be responding to questions today or giving testimony raise your right hand. Ask you to swear or affirm under penalty of perjury that the testimony you are about to give to the Committee on Public Works and Operations is the truth, the whole truth, and nothing but the truth. Do you swear or affirm? Thank you. You may begin your testimony.
Good morning, Chairperson Nadeau, committee members, and staff. My name is Colleen Curry, and I am the Chief Administrative Law Judge for the Office of Administrative Hearings. Thank you for today's opportunity to testify about OAH's accomplishments and challenges during fiscal year 24 and thus far into fiscal year 25. Fiscal year 24 and the first quarter of fiscal year 25 presented some challenges to OAH's operations, the greatest of which being the continued increase in our overall caseload. In fiscal year 24, OAH saw the largest number of filings in its 20-year history. 33,745 cases were filed, constituting a 28% increase from fiscal year 23 and a 119% increase from fiscal year 21. And in the first quarter of fiscal year 25, OAH saw 12,652 new cases filed, which constitutes a 46% increase from the first quarter of fiscal year 24. If the rate of new filings continues throughout fiscal year 25, over 50,000 cases will be filed this year. The largest number of filings were seen in the enforcement cases from the Department of Public Works, the Department of Buildings, and the Washington Metropolitan Area Transit Authority, and in appeals from decisions made by the Department of Human Services. In particular, DPW filed 11,459 cases, which constituted 34% of all filings and a 29% increase from fiscal year 23. DOB filed 9,557 cases, which constituted 28% of all filings and an 11% increase from fiscal year 23. WMATA filed 3,478 cases, which constituted 10% of all filings and a 1,116% increase from fiscal year 23. And public benefits claimants filed 3,791 appeals arising from DHS decisions, constituting 11% of all filings and a 51% increase from fiscal year 23. Despite the increased use of technology and the resulting efficiencies that I will discuss shortly, OAH has struggled to manage these increases for multiple reasons, central of which is insufficient staffing levels. But before I discuss that larger issue, I would like to briefly discuss some case-specific issues that have impacted OAH. WMATA began filing fair evasion and unlawful conduct cases with OAH in fiscal year 23 when it filed only 286 cases. In fiscal year 24, OAH saw more than 12 times as many WMATA cases filed. If filing continues at the same rate as in the first quarter of fiscal year 25, OAH will see as many as 6,600 WMATA NOVs filed in fiscal year 25. Putting aside the challenges surrounding managing such an increase in caseload, OAH also has difficulty adjudicating these cases because almost every NOV filed with OAH by WMATA has been deemed legally deficient for various reasons. NOVs filed by WMATA are often illegible or have missing pages. Worse, the apparent NOV template in use by WMATA includes incorrect and missing information. WMATA NOVs direct respondents to file their answer with OAH through a non-existent email address and include the false warning that penalties will be imposed for failure to answer. There is simply no evidence that the respondents have been provided correct information regarding how to file appeals to OAH, a situation that violates basic principles of due process and requires the NOV to be dismissed outright. Although OAH has communicated these issues to WMATA, both through orders dismissing cases and through communications to OAH's points of contact at WMATA, the problem continues. With respect to cases arising from decisions made by DHS, the rapidly changing statutory and regulatory landscape of the Family Rehousing Stabilization Program has caused multiple issues for OAH. In addition to the uptick in appeals filed as a result of these changes, whether OAH has jurisdiction to hear an appeal has also changed with applicable legislation and regulations. While OAH has made a series of necessary pivots in how we handle the abundance of appeals due to changes in the law, the agency still often finds itself caught in a bind with respect to timing in light of the increased caseload. DHS does not conduct administrative reviews in a timely manner, which means that although cases are filed at OAH can do nothing beyond conducting a status conference, essentially putting the case on standby until DHS has conducted its administrative review. This causes significant delays for OAH and increases workload for administrative law judges and staff alike. Rather than conducting hearings on a ripe case and adjudicating that case to its conclusion, OAH is frequently left in a position of waiting for DHS to make its determination before acting, thereby causing a persistent strain on OAH's ability to meet critical statutory deadlines for adjudication. Turning back to staffing-related issues, at the end of fiscal year 23, OAH engaged B. McNamee Consulting to conduct a staffing study. As part of its final report, BMC provided OAH with a tool for projecting the number of staff required to timely process and adjudicate cases based on the caseload for any given year. Based on BMC's weighted caseload study, a very rough calculation using that projecting tool suggests that OAH needs at least 50 ALJs and 85 clerk's office staff actively working on cases to manage its caseload at fiscal year 24 levels. Through both local and programmatic funding, OAH currently has 36 ALJs and 41 clerk's office staff members who work directly on cases, not nearly enough to handle the previous fiscal year's caseload, let alone the one projected for fiscal year 25. Through rigorous recruitment efforts, at the end of the first quarter of fiscal year 25, OAH had 13 vacancies, roughly 12% of its positions, which was down from the end of fiscal year 23, when OAH had roughly 25% vacancy rate in locally funded positions. However, due to the status of OAH's current fiscal year 25 budget, OAH currently has no hiring plan. Thus, while OAH has been able to successfully recruit for its vacant positions, the unfilled positions will remain vacant, further exacerbating OAH's capacity problem. Despite these challenges, OAH has accomplished much in the last year. First, I am very proud to announce that on September 30th, OAH published to the web a search portal which provides public access to OAH's final orders. This significant achievement, which was years in the making, provides attorneys, litigants, and the general public with an efficient way to access final orders. Providing online access to our final orders allows members of the public to gain a deeper understanding of how OAH ALJs adjudicate cases, including what laws applied, how that law is interpreted, and what evidence an ALJ considers in making their decisions. This new tool represents a major milestone for the agency and reflects our ongoing efforts to improve transparency and accessibility. Second, over the past 3 years, OAH undertook a comprehensive overhaul of its rules and issued final rulemaking on November 15th, 24. The new rules went into effect on December 1. This marks an important step in refining our operations and enhancing our ability to serve district residents effectively. Contemporaneously with revision of the rules, OAH undertook a thorough review of forms available to the public with the goals of aligning those forms with the revised rules and increasing the use of plain language. Third, based on recommendations from both BMC and Mondrian Consulting LLC, OAH has taken steps to exploit more of the tools available through OAH's case management system. In particular, we have developed workflows and business rules to increase efficiencies within our digital processes and continue to review and analyze current processes to determine what other efficiencies may be realized with use of those tools. These are changes OAH could make with little or no additional funding. While there is potential for more improvements, such improvements will require additional funding that OAH currently does not have. Fourth, OAH fully staffed its Resource Center. Resource Center staff have been working to bolster delivery of self-help services by updating guidelines and policies, streamlining methods for tracking and recording key data points, launching a new call system, expanding availability of in-person services, and adding direct contact information for the Resource Center to all OAH orders. OAH is also exploring the potential to build volunteer programs in order to expand services. Finally, OAH commenced 2 initiatives in fiscal year 24. First, in establishing the Public Benefits Task Force, OAH began a deep evaluation of processes related to public benefits cases, specifically evaluating physical and IT workflows with the intention of reducing waste and delays and increasing efficiency. And as Chief ALJ, I convened the OAH Data Governance Committee to build a strategic plan and policy related to the governance of data at OAH. Data governance is the framework by which OAH reaches and communicates decisions around data, ensures that business activities and data management are synchronized, and develops and documents long and short-term strategies around the collection, use, and publication of data. This committee will centrally oversee collection and dissemination of data, address emerging issues of data governance, and manage policies and practices surrounding governance of all OAH data. On a final note, OAH celebrated the 20th anniversary of its formal operations. OAH has come a very long way from those first years. Our staffing levels and caseload have both increased, and the range of case types have expanded. In preparation for that celebration, I read through the Center for Court Excellence's September 29, 1999 report to the DC Office of Corporation Counsel entitled "A Final Report on Creating a Unified Administrative Hearings Agency." The executive summary included commentary that resonated with me. CCE recommended establishing OAH to combat a few specific issues, which included a wide disparity of qualification for hearing officers, timeliness of decisions, the independence of hearing officers within each agency, and the short funding of the adjudication units within those agencies. I firmly believe that OAH has succeeded in recruiting and retaining highly qualified ALJs and maintaining a strong policy of decisional independence. But 20 years on, OAH continues to see staffing and funding shortfalls, which impede our ability to effectively manage and timely adjudicate cases. Ms. Chairperson, thank you for your time and interest in OAH. In closing, please allow me to publicly thank those who were most instrumental in helping me prepare for today's hearing. Chief Operating Officer Lachelle Jenkins, who is seated to my right, General Counsel Smriti Radkar, who is seated to my left, and Executive Assistant Jacqueline Spetzer. I would also like to extend my sincere gratitude to the staff at OAH for their steadfast commitment in administering justice on behalf of the residents of the district. I'm happy to answer any questions you may have. Thank you.
Thank you very much. I really appreciate your testimony. Just to make things a little easier, I'm going to ask my questions in the order of the topics and sections that we sent in the pre-hearing questions. And I'd like to begin with an overview of the agency's organization and staffing. But first, I want to ask about some of the key accomplishments the agency was able to achieve in the past year. Can you describe for the committee some of the major activities carried out during fiscal year 24 and the accomplishments of which you're most proud?
As I said in my testimony, the final order search, our dissemination of that, and the rules are really the two top things. Our rules had not been overhauled since they were originally implemented in 2004. So 20 years later, we finally had a chance to really do a deep dive into making sure that the rules matched what our current processes are. And along with that, we made sure that we did a thorough review of our forms to make sure that they complied with the new rules, but also to really look at those for plain language to make them as accessible as possible. So it was multi-stage, not just the rules, but also our internal orders to make sure all of our boilerplate language complied as well. So that was it. And the final order search, that's something that looking back through the history, it's since at least 2010, it's been something that's been asked for. And it was a huge undertaking because not only did we have to figure out how internally how to do that efficiently without creating additional work for a large amount of additional work for staff, but also within a budget that we had, which was not very large. And it is a floor. And I think I said this a couple of years ago when we talked about our e-filing portal. I think that was last year. This is a toe in the ocean. We had to start somewhere. This is our floor. This is where we're starting. It's not perfect. We know that, but it's a start. And I'm really proud of where we are and the fact that we are publishing our orders. Those are the two big things. I could go on. There are lots of other little ones, but.
That's good for now. And we'll get into the final order database a little later too. So thank you for teeing that up. What about any ongoing barriers that can be addressed either by this committee or the council as a whole?
Staffing, that's the big issue that we have, I think. And, council funded for us a staffing study, which we had never had. This was, sort of our groundbreaking here. This is where we are at the end of fiscal year 23 with the caseload that we had at that time. This is what we needed. BMC did a weighted caseload study, and they provided us a tool to look for. And we needed to wait for fiscal year 24 to get our final numbers so that we could take a look at that. And crunching those numbers, we're still going through and fine tuning it. But even at a basic level, we are seriously understaffed. With our caseload and burgeoning caseload, as I just testified, we need at least 50 ALJs and 85 legal assistants or legal administrative specialists. Our caseload just continues to increase. And also, as I testified, the other burdens that are problems that we are having originate from the agencies whose cases we hear. The increases in cases from WMATA, that's a real pain point because we are doing a huge amount of administrative work without actually ever getting to the merits of these cases. And that's a problem because every single one of them that we've seen are legally insufficient. They do not meet basic due process rights. And that's, 34,000 cases that we have to process and don't actually get to the meat of the issue. And then the issues that we're having with the DHS cases. Now, I do want to note, we do not have an MOU with DHS because we are statutorily obligated to hear those cases. And the fluctuations in the law and the changes that have impacted our agency, we've been able to pivot, but that has created additional administrative work for us. And then the fact that the agency is not doing the administrative review in a timely manner, which makes us have to delay our issues. It is domino effect that we're having. Those are some of the big issues that we're having. And then, going back to our IT, we still are trying to figure out how to bring our systems up to date, especially in the courtroom. And that's an issue that we have for when we do have in-person hearings.
Mm-hmm. What is the 85 people you need to support the ALJs? What position did you say that was?
Those are in the clerk's office, legal assistants, legal administrative specialists, and deputy clerks. I have not, one of the things that we would need to do to figure out which position is to refine our analysis. As I said, this was really sort of a big back of the envelope. What are the big chunks of numbers that we need before we can figure out exactly how much of each we need?
Is that in progress or is, okay,
It is.
great. How many total employees work at OAH?
109.
And how many of them are ALJs?
We have 36 ALJs plus myself. So 37.
And how many vacancies do you have in ALJ positions?
Right now, we have 2 vacancies. One was a resignation at the end of last year, and the tragic loss of our colleague last week created a second. And I do anticipate 2 more vacancies at the end of May, for sure. We have a couple of ALJs who have submitted retirement notification. So we'll have at least 4.
Are you able to recruit for all 4 at once?
We will do that. At this point, I don't believe we'll be able to fill any of those positions. We're still doing analysis, but probably won't be able to fill any of the positions until mid-July.
Because of your budget allocation?
Yeah. I'm sorry, yes.
It's okay. It means the same thing. All right. My 4-year-old gets very upset when I respond affirmatively with the word sure. It's just not clear enough for her. So, anyway, can you walk me through why that is? Like why the math works that way? So you have 2 vacancies right now, but you can't afford to fill them. Weren't they budgeted?
I'm going to refer this question to, sorry.
Good afternoon, Councilmember Nadeau. My name is Judith, and I'm the budget officer for OAH. And yes, those positions are allocated or are budgeted for. However, in our first quarter, which is just a projection based on the filled positions currently, we are looking at a deficit. So it's just a projection. So we are still working with the agency to ensure that the recruitment efforts that they're doing are doable. But even though right now they are budgeted, like I said, we are looking at a projection of a deficit in the first quarter.
What causes the deficit?
Right now, basically, the current positions on board. And since there are going to be some vacancies, we are trying to see if in quarter 2 that will basically play out so that the agency could break even.
Can you explain this to me like I'm a 6-year-old? So the positions are budgeted, but there's still a deficit?
Correct.
How does that work?
So basically it's the amounts of salaries that were projected. There are salary adjustments that basically based on the actuals and the projected are not in how should I say, in level or align. And that's basically what causes a little bit of the deficit, but it is a projection. And that's why we are continuously working with the agency to ensure that the recruitment process isn't really affected or basically trying to see how we could help the agency in the recruitment process, looking at our budget to make sure we stay aligned with it and looking at the actuals versus the budgeted.
So how does that happen? And someone's salary is just higher than what was budgeted?
Yes, and sometimes also the fringe benefits. Not everybody has the same fringe benefits, and some may be up, and that basically also disbalances many times the budgeted positions.
What is that just based on which health plan they elect
Right.
or?
There's either family plans, which are higher than if you're a single person and not having either no health insurance or maybe just a single. But yes, the family plans seem to be higher, and a lot of people in the agency basically have a lot of fringe rates.
How are our margins that slim? Okay. All right. This is mind blowing. All right. How many ALJ positions are vacant?
One moment, please. Sorry.
Sure.
10.
Is there the same sort of effective hiring freeze on those positions?
Yes.
Okay.
Oh, I'm sorry. 11. Let me correct that.
11. I see 9 vacancies in the clerk of court division, which is the largest number of vacancies compared to other divisions. Why are there so many there in particular?
That was the largest share at the end of fiscal year 23, and we've been recruiting very rigorously. We've been really successful, and our retention rate has gone up. But we're not able to fill all those positions in the time that we had so far. Unfortunately, recruitment takes time.
Understood. Can you talk about who the ideal candidates are for those positions? Is it recent law grads? Is it people already in the workforce? How do you think about who you're looking to fill those positions?
It really depends on which position. For the clerk's office, we're not looking for recent law grads. We're looking for individuals who have data entry experience, who have some experience in the workforce, and have at least some or a basic knowledge of court process. So it doesn't have to be somebody who has been a legal assistant in a law firm or anything like that, but somebody who has a basic understanding, and somebody who has some professionalism with them.
Mhm. Thank you. So glad to see the new position for the Resource Center Coordinator filled. We were really excited to fund it, so thank you for filling it. And we also funded an IT specialist position. Has that one been filled yet?
We had all 4 positions filled, and one of our hires after a couple of months left.
Which position was that?
That was one of the new IT positions.
Got it.
And we're unfortunately, that's one of the ones that we cannot fill right now. So we have 3 up from 2, which is better than just 2.
Yeah. The agency goes through OCP for contract and procurement, right?
Correct.
Okay. Have you had any issues with OCP over the past year?
Ms. Jenkins will answer that.
No, not this year. We've actually had a smooth year with OCP.
Great. Love to hear it. Okay, let's talk about the 2024-25 performance plan. In your opinion, what do you think is the difference between a successful program and a failure?
In terms of
Agency
define program?
performance. Yeah.
Agency performance. Well, in particular for OAH, if we are meeting our goals of adjudicating more cases that come in, so that we're more than 100% closure rate, and we are addressing cases within statutory regulatory timelines, and we are able to schedule hearings on cases where we have a live dispute, as basically as soon as they come in, that's a successful program.
That's really helpful. Thank you. One of the agency's goals is to increase operational efficiency in OAH's resolution of administrative disputes. Can you talk about how you're going to achieve that goal?
That is in relation to making sure that we are adjudicating our cases timely. And unfortunately, we have no control over our caseload. But another piece of that is ensuring that our internal processes, how we're managing, processing the cases internally, how our workflows work is as efficient as possible. And we've been doing, as I mentioned, and especially in the public benefits realm, we've been doing a deep dive into what those processes are, how we can refine our processes to not only increase efficiencies for both the processing and the adjudication of those cases, but also how we can capture the data that we need to make sure that we're meeting mandatory reporting requirements. So that it's a multiple faceted research.
Thank you. You mentioned in your testimony that DHS doesn't conduct administrative reviews in a timely manner, and although cases are filed at OAH can't do anything beyond conducting a status conference. Is this something that attributes to the significant delays and inability to meet statutory requirements?
Yes.
Can that be fixed through legislation?
I think so. I think it has to do with what the requirements are for the agency to conduct those reviews, what the requirements are for petitioners seeking to waive that requirement and just come straight to OAH. There are some, I think that there are some vagaries and gray areas that could be changed statutorily. I would have to go through the statutes and the regulations, but I also think some of them are federal, especially in relation to Medicaid processing.
Oh, yeah, that makes sense. Do you happen to know where in statute, whether it's federal or DC law, that the cases are referred to OAH really before all of the DHS process is complete and they haven't done all of their work?
I'm
Yeah.
not as familiar with that specific statutory process. I believe it has to do with the fact that at any time a petitioner can file an appeal of a decision, initial decision, and that has to do with whether the benefits continue while DHS is waiting to make a decision on any sort of administrative review.
Oh,
And I
that's
think
kind of
that's,
important.
yeah, I think the timing is very important.
Yeah.
So I think it has to do with that, but I apologize. I'm not
No,
that
no, it's
familiar with
okay.
that area of the law.
We can talk more about it later,
Yeah.
but it is obviously something that has to be approached with a fine instrument, given the fact that it's
Yeah.
people's benefits and we don't want to
Yeah.
cut them off while they're waiting for a decision. Okay. What additional resources does OAH need for FY25 in order to move towards your goals?
We need more budget to be able to fill our staff.
Yeah.
Our vacancies are really problematic. And some funding that would allow us to spend some money on creating efficiencies that we would like to create within our systems. So IT, basically.
Yeah, I will ask. Could be remembering this wrong, but did you all have a reprogramming this fiscal year?
Yes.
Yes. How much was it?
Yes, it was approximately 6,900, but it was just to move non-personnel to non-personnel for this fiscal year to load some of the.
Within the agency?
Yeah, within the
Okay, I don't
agency.
care about that.
Yeah.
All right. That's fine.
Okay.
Okay. Um, some of the testimony today was about a need to revise MOUs for better workflow or better outcomes. I know one of one of OH's new goals is based on, I'm sorry, one of your new goals based on the FY25 performance plan is to exchange information with agencies. Can you talk more about that?
We would like to have better communications with agencies with respect to increases in their caseloads, anticipated increase, changes in regulations, or changes in enforcement of existing regulations so that we can anticipate better impacts on our caseload. With respect to MOUs, I think that if you have ever looked at our Establishment Act and the section of our Establishment Act that describes our jurisdiction, it is a mess. And I think MOUs, that we have several MOUs that cover issues that are already under our jurisdiction. And we're trying to figure out ways to avoid having to do that so that we don't have to rely on MOUs. So that's the issue of MOUs is a bigger long-term issue that we need to look at. But more than that, going back to your question, it's really having better communications with the agencies whose cases we hear so we understand better and can anticipate better changes in our caseload. And if there are issues that we see, for example, with like the MOMATA issue that I was describing, if we have a better point of contact and better communication, we can share that information with trends with them. And so we can get more response and hopefully serve the citizens of DC better.
Do you generally have good comms with these agencies or is it a struggle?
There's a spectrum.
Yeah. Okay. I'd like to highlight to my colleagues with different jurisdictions where those gaps are. So if you would like to share any of that at a later date.
Sure.
So as not to publicly embarrass everybody involved, but to try to get at that through oversight, I think that would be very beneficial and that this body would be eager to assist.
Thank you.
Yes. Okay. Also, if the Establishment Act is a mess, we should maybe look at that together.
Yes, I
Okay.
agree. 100%.
Okay. In all of your spare time.
Yes.
Okay. Let's discuss one of the agency's goals of managing and resolving disputes. Can you talk about how the agency handles DPW-related infraction violations that are issued to the wrong person?
When we review the case, it depends on if we have an answer or not. If somebody has answered and denies the allegation based on this is a case that is not my property, it's assigned to a judge for adjudication. Either if the person has submitted a written answer, it's done on the papers. If they've requested a hearing, it's done in court, and the judge would look at that and make a decision. So it's basically the same adjudicative process. For those cases that are where there is no answer, they're put in our queue for reviewing and disposition by default.
Okay. How often does that happen?
I don't know the answer to that question. I would have, and I don't know that we have a data point to be able to track that. I don't think it happens as frequently as it could, but it's
in my inbox a lot. So there's that.
okay.
but it's anecdotal, obviously.
Yeah.
So that would be something that I'd like to work on with DPW. And I think that might be my project this year with them, one of them. So you may be hearing from me on some of that data.
I would be happy to discuss that with you.
Thank you. In FY24, OAH commenced a public benefits task force. Your response says that the expected results are the reduction of waste and delays and an increase in efficiency. Can you say more about that?
Yes. The way we process internally the cases, so in our case management system, hasn't really been evaluated since we started using our case management system in 2010. Laws have changed. The programs that we adjudicate have changed. And we're also working with the agents, the public benefits agencies whose cases we hear, to make sure that we understand what data points that they need. And so we're looking at the processes, how we're characterizing these cases, the processes within our systems, how a case is processed from start to finish by the clerk's office, how it gets to an ALJ, what is available to assist the ALJ in writing their orders. All of those pieces, we're taking a very big look at them to align them with the statutory and regulatory requirements, the data reporting that we need to do, as well as efficiencies for all the parties internally, so that we're doing things more efficiently, which means that the cases are being processed and adjudicated more quickly and efficiently.
Thank you very much.
You're welcome.
Why doesn't OAH have a policy on data governance yet? Is that something in progress?
It's in progress, and this is something where we are, in my understanding, talking to the Chief Technology Officer's office about data governance. We're sort of on the leading cusp of agencies in having a real policy that talks about how we govern our data, how we collect our data, and trying to be as consistent as possible. You know, since council confirmed me as chief in May of 2021, the multiple questions and inquiries we've gotten about our data and how we've been collecting data, we have started looking at and realizing that a lot of what we were doing in the past, we were getting inconsistent issues because the way we were doing it, the way we were collecting the data, and also the way that we were analyzing it was inconsistent. So we're trying to create consistent processes for all of our data collection and all of our dissemination and analysis, so that we're always consistent with what we do. I don't know, that's probably too much information.
No, that's great.
Yeah.
I like to understand the way you're thinking about it.
Yeah.
Very
So it's frustrating if, you know, we have one person who's pulling data to answer a question from an agency in one way, and our official response through answers to council is something different. And it's just because of the way that we're looking at how we're answering the question. So we're trying to centralize that to make sure that we're pulling everything consistently, so that we're answering the question the same way, even if it's coming from two different places.
Great. Love that. What's the agency's work from home policy?
We're consistent with DCHR, which is all employees who have been with us for more than 90 days can request telework 1 day a week.
Okay. Just digging in a little bit to the current public benefits backlog. And of course, that one has, SNAP in particular has that 60-day timeline. What is your plan for addressing the backlog now? How are you attacking that?
I'm working with the principal ALJ and the deputy clerk, the attorney advisor, the group, the broad group who really looks at those cases, processes and adjudicates those cases, to try and figure out what processes we can use to increase our efficiencies and to address those as quickly as possible. It's in progress right now.
Okay.
And it's also part of the bigger picture of the task force that we're working on.
Any early conclusions or ideas about how it might work?
Not right now.
Okay. Do you have standardized guidelines for when to approve or deny a request for an emergency hearing in a public benefits case?
I don't know the answer to that question. I'd have to check with the principal ALJ about that.
Thank you.
You're welcome.
The oversight responses cited limited availability of staff from sister agencies to attend hearings as one of the causes for the public benefits backlog. What are the most common practices of agencies with appeals heard by OAH that impede OAH's ability to process and resolve cases?
My understanding is that those agencies have only a specific number of individuals who are available for hearings at a specific number of time, and they can only cover a specific number of hearings at a time. And with the combination of those limitations, as well as the capacity of our judges, which there's only so many hearings a judge can hear in a day, that combination really limits how many cases we can hear at a time.
Is it the kind of thing where that day that representative is just like on their cases are all scheduled and you go through a bunch of them?
My understanding is that they can only have a capacity of a certain number of cases per day per person. And they're only available certain days. And so if we schedule a case for that agency on a day when somebody's not available, nobody's going to show up, which doesn't help us
No.
adjudicate the case. And our judges, as I said, only have so much capacity. So I can't schedule 30 cases for a judge in a day.
Yeah, it sounds like a scheduling nightmare, actually.
Yes,
And
it is.
what are who do they send? Is it like a general counsel?
It's representatives from the agency. I don't believe it comes from the general counsel's office, but I don't know the answer.
I'm sure it differs, but I'm
Yeah.
curious sort of who,
Yeah.
if it's,
Our broad swath of agencies of whose cases we hear
Yeah.
really depends on the agency who they send to a hearing.
what changes will OAH make to come into compliance with the federal requirement that administrative review conferences cannot delay the fair hearing process?
That's something that we're looking into figuring out.
Is that part of the task force too?
Yes.
How do pro se litigants find out about the services the agency provides?
In terms of, you mean like
Resource center or other?
the resource center, we now on all of our resources are available on our website, first of all. If somebody calls, they can request to be referred to the resource center. And when a scheduling order is sent out to the parties, there is information included in the scheduling order that talks about other resources available, specifically language access. And then a lot of the appeal forms have information available to them about what resources are available at OAH. So we try to make sure that it's available on many different levels. And the clerks who answer the phones are also trained to provide information about what's available.
But it's sort of built into the boilerplate of what goes into the scheduling order and other
Yes.
documents that
Yes.
are sent to the pro se litigants. Okay. You mentioned that the resource center is launching a new call system. Can you talk about that?
The call system actually has been launched, and it's an AWS call system, which allows a party to be referred directly to the resource center. We have individuals who are available to answer the phone. If somebody's not available for some reason, then there are ways for the individual to leave a message so that somebody will call them back. The system allows us to collect a lot of data and to review calls for quality assurance. So we will be able to tell if somebody needed language access. We'll be able to tell how long the telephone calls were, where they were referred to. So there's a lot of data that goes with that will help us really refine our processes.
That's great. Okay, so talked about in the very beginning of your answers here, the online final order database. you mentioned we're at the floor right now. Let's talk about the searchability because that came up a lot in testimony. How in its development were you all thinking about sort of how users will approach it and how can we get it closer to what people need?
We really took a deep look at what we could do and what the potential for growth was. And the way we decided to go was within our own case management system. Our case management system has a lot of really huge benefits to it. Our e-filing system is built into that. This allowed us to keep all of that data within our case management system, which made our internal processes much easier. This system is the company that we work with, JTI, who is our vendor for our case management system, they have a very forward-thinking look on how things are done. So I do expect that we will be seeing changes as we move forward. But we wanted to make sure that we were able to provide something as quickly as possible that met the basic requirements that we needed, which was getting them online, allowing somebody to look and say, I want to look at DOES cases. And we're still looking at it and refining it as we can. So
Does it have the ability to do keyword search in a future iteration?
right now, it doesn't, but that my understanding is that there are multiple clients of the vendor across the nation, actually across the world, that have requested that.
Okay.
And so it will most likely be slated for upgrade. I can't guarantee it, and if after a few years it isn't, then we'll have to reevaluate.
Okay.
Because I understand the importance of that.
Yeah. Is that something that exists in your case management system?
Within our case management system, the pieces that we have that are public facing, it doesn't. We are looking at what they call it an elastic search, which is basically Boolean search, that would be the internal piece. And so they are starting to roll that out, which gives me hope that it will
It
start
could
working.
mirror on the public side.
Yeah, on the public side. So
Yeah.
unfortunately, that costs money.
Right.
For us internally, and it will for external. So, we're sort of in a bind. They have it, we want it, we're waiting to see how much it would cost, and then we have to figure out if we can pay for it.
You'll let me know.
I will.
Okay. Anything we can do over here with the vendor and urging them to move faster on that keyword search functionality for the public database?
I don't think so. They're very responsive. So thank you though. If there is something you can do, I will let you know.
Okay. That concludes today's performance oversight hearing. If you plan on submitting written testimony for the record, please do so by going to the council hearing management system at lims.dccouncil.gov/hearings. The record will close on Thursday, February 20th at 5:30 p.m. I'd like to take a moment to remind the public that the Committee on Public Works and Operations will be holding more performance oversight hearings over the coming weeks. Please visit our hearing management system for our schedule and to sign up and testify. Thank you to OAH for your testimony today. The time is 11:19 a.m. and this hearing is adjourned.
Thank you.